So hi, and today we're joined by Anne Slater-Brooks from TriplePoint. You're very welcome, Anne.
Hi, nice. Thanks for having me.
Pleasure. Good to have you with us. We're going to be talking about a particular subject today about business relief investments. And at the top of the call, we'll give the risk warning. So right and proper to state that none of this is advice, and anything we talk about today, if it piques people's interest, they should really go and seek professional financial advice before ever pursuing that. Fair enough?
Fantastic.
Always good to get the warnings in first. So business relief investment, but obviously that's your bag. Can you explain to us in words of one syllable what they are and how they might benefit clients?
Okay, so that's actually quite a long question to answer. So I'm going to start with what is business relief, and then I'll come on to the possible benefits.
Sure.
So just to give a little bit of background, so business relief was first introduced by the government back in 1976. And it was introduced really to help preserve small family businesses when one of the shareholders passed away. So providing that shareholder had held shares in that company for 2 years and they still held the shares at death, they would qualify for an exemption on the value of those shares in their estate. So they get full inheritance tax relief after just 2 years.
Yeah.
So that was back in 1976. And then since then, companies such as TriplePoint and others in this space have developed services that allow private investors such as your clients to invest into a trading company with the view of obtaining business relief. The difference is that whereas themselves, if they had a trading business, they would have to run that business. In this case, we take on all that responsibility for them. So for them, really, it just feels like an investment. But as long as they've held the shares for 2 years and they still own them on death, they can take advantage of that business relief exemption. So I guess going on to your second question about the benefits, that's probably one of the key benefits for clients, in that unlike traditional estate planning, which might involve gifting or gifting into trust, there's generally a 7-year clock applying to that type of planning. Whereas this is very much a quicker way to get the same outcome, in that it is that 2-year holding period. And by the way, that's 2-year holding period between spouses. So if one of them unfortunately didn't survive the 2-year period, but the surviving spouse did, then they've achieved the same objective. In terms of other key benefits, I think the principal one that I tend to talk about is access. So again, if you're comparing with traditional forms of estate planning, generally speaking, gifting requires that the person who's gifted can no longer take advantage of that asset or those funds. So if you decided you wanted to gift a family home in Malta, for instance, you wouldn't still be able to continue going and using that property in Malta. You have to give it and give up any access or use of those assets.
So you've lost control effectively.
Exactly, and you've lost the enjoyment of the asset as well. So that was a very typical form of planning back in the sort of 80s and before that, but that loophole was closed down back in 1986. So you can't do that anymore. If you're gifting, it's got to be outright gifting, no strings attached. You can't benefit from that asset. With this type of planning, it's not involving gifting at all. It's just investing into assets that can take advantage of this legitimate relief that's introduced by the government. So as a result of that, clients can have full access to those funds. So should circumstances change and they decide that inheritance tax planning is no longer that important to them, they could access the funds by selling off those shares effectively. So it's those two key benefits, really. It's the 2-year versus 7 years, and the access versus no access, which are the big drivers for people looking at these types of investments.
So potentially quite a lot of flexibility around that, really.
Oh, lots of flexibility. And that's what makes them suitable for such a wide array of clients. Yeah. Although obviously the first criteria is that they need to have an inheritance tax problem.
Yeah. No, understood. So you touched upon the tax benefits there. So can you expand a little bit around that in terms of specific tax benefits?
Yeah, so there's 3 tax benefits really, but the most important fundamentally is the inheritance tax relief. So as I say, once they've held the shares for 2 years, they hold them on death, they get 100% relief from inheritance tax. So to give an example, let's suppose the value of the shares was worth £1 million. After 2 years, they would have effectively saved 400,000 in inheritance tax on those shares. So there can be quite a substantial benefit from these types of investments because there's no limit on the amount that you can invest into these types of solutions. Whereas normally, if you were doing trust planning, you're limited in the amount that can be done every 7 years. So it can take a lot longer to reduce the tax on a very big estate, or even an estate of a couple of £1 million. It can take a lot of cycles of 7 years to really fully get rid of the issue.
Yeah, unless you want to incur a lifetime charge anyway.
Exactly. And the other 2 points, because I did say there were 3 points, so these are less important points, but they're still worth mentioning, I think. So because your clients are buying shares in these companies, any growth in the value of those shares is subject to capital gains tax. Now, if the clients hold these shares on death, as they're intended to do, because they've effectively purchased them because they want the inheritance tax benefit, they will also get a capital gains tax uplift. So any growth in value at the time of death effectively gets wiped out. The growth doesn't get wiped out, I hasten to say. The tax on the growth gets wiped out, just in case anybody was wondering at that point. So they effectively get an uplift in the value on death, so they can avoid CGT quite legitimately at the point of death. And the thought process there is it's because effectively it becomes subject to inheritance tax, although that wouldn't apply if the shares have been held for the 2 years. The third point comes back to what I was saying about access. So if you've got clients who do decide, actually, my circumstances have changed, I've decided I'm going to go blow all my money and take a huge cruise around the world, obviously in times other than the moment, then in that scenario, they can withdraw their monies by redeeming shares. So that redemption is again a capital gains tax event, but as many people will be aware, capital gains tax is at much lower rates than income tax. So it's still a much more efficient way to get their monies back than if they were subject to income tax. Generally speaking as well, we find that most clients will probably pay little or no CGT because they can use the annual exemption on the shares. But obviously that entirely depends on the circumstances of each client. And again, it's why we really do suggest that they seek financial advice before doing these types of investments.
Of course. But as you say, the these particular arrangements, the legislation enabling them has been in place for a number of years now. So this isn't sort of pushing at any envelope. This is relatively straightforward, recognised stuff.
Yeah, and actually that's a really good point to make, because sometimes when I tell people what I do for my role, they'll say things like, oh, you're one of those brigades that do anti-avoidance schemes. This is absolutely not anti-avoidance schemes. This is stuff that has legitimately been introduced by the government, and we're offering solutions that allow clients to take advantage of those reliefs. Like you said, this has been around almost as long as I have. And there's been a number of different governments in that time as well. So it's a relief that has been supported by governments of all different kinds, if you like. It's not just that it's been supported by the Tory party.
No, it's interesting to know. So we've talked about the upsides, the benefits, and so on. Tell us the other side of the coin, and give us the risks. What are the risks associated with this particular arrangement?
So the principal risk is that your clients are effectively buying shares in an unquoted business. So the risk is that that business may fail. And again, this comes at the risk of repeating myself. This comes back to why it's so important to seek financial advice, because ultimately it's really important to dig under the bonnet and look at, well, what does that business that your clients will be buying shares in actually do? And how diversified is that business? And this is where a financial advisor can really help clients to establish the risk of an individual offering. So, for instance, with TriplePoint, it's a bit different to some companies. What we effectively do with the money that we raise from clients looking to save inheritance tax is we provide finance to SMEs, large corporates, public sector, local authorities. So what we do is not dissimilar to a bank, although I have to stress it does not carry the protections that a bank deposit would. But a bank does the same kind of activity with the money that it raises that clients put on deposit effectively. But there are lots of different types of investments that clients can access in these services. And as I said before, and I am in risk of danger of repeating myself, this is why it really is important to seek financial advice. And I touched briefly upon diversification then. I think diversification is worth just expanding on a little bit more. And to try and simplify this, if I was looking at a company to invest in and that company had just one client, I think most people would recognise that that company is a much higher risk than another possible company that I could invest in that's got thousands of clients. And different business relief services from different companies will have a number of different assets or underlying contracts and trades. And again, it's really important just to have a look at that level of diversification to try and ultimately get as diversified a portfolio as possible and mitigate some of that risk of investing into an unquoted business.
Okay. So as you say, there's swings and roundabouts. There are benefits and risks, and quite rightly, it's about the client being advised accordingly as to the suitability in their case, the appropriateness, and how those risks and rewards should be balanced up and considered.
Definitely.
That's a fair way of putting it. So talking about suitability, and there's no such thing as a typical client because every client circumstance are different naturally, and there's no one size fits all. But are you able to give some sort of generic examples of the sorts of clients where this might be where they might want to consider at least the use of this?
Yeah, the great thing with this is there's so many. So that's the nice thing to start with. But having said that, the key thing is that first and foremost, this is suitable for clients who effectively have got an inheritance tax problem.
Yeah.
But there are lots and lots of different types of clients that have got an inheritance tax problem. So perhaps one of the most common areas that we see these investments used for is for elderly clients. So clients in their 80s or their 90s where they are less confident that they will survive a 7-year planning period using more traditional methods. And they perhaps are more confident that they'll survive the 2-year period. So we see a lot of clients that fit into that group. On a similar vein, clients that aren't in great health. So if they have got a variety of different health conditions and perhaps don't feel that they are likely to survive the 7 years, that 2-year period could be a lot more appealing for them.
Yeah.
But equally, I always say to people, this is not the preserve of the elderly only. These types of solutions are just as suitable and just as useful for clients that may be in their 40s and their 50s who've either built up wealth independently, perhaps they've inherited it themselves, or it may be that they've sold a business. Whilst the argument around 2 years versus 7 years is kind of neither here nor there at that point.
Yeah.
The big difference is in outlook. So somebody who's in their 40s and 50s with an inheritance tax problem may be less inclined to start thinking about gifting, even though they will more than likely survive 7 years, purely and simply because they're thinking, well, what happens if I survive 40 years or 50 years? What if I end up with too little money to survive? So they're not ruling out gifting, but they might be saying not yet. So this can be suitable for those types of clients who are just not comfortable with the concept of gifting at the moment, still want to retain access to the investments, but do want to address the inheritance tax problem. And one of the real crucial areas that we see cases is where clients have sold businesses. So they might have sold that business for quite a substantial amount, and that sale has actually given them quite a significant inheritance tax problem. And often that would have been a business that in itself qualified for business relief.
Yeah.
But once they've sold the business, they no longer can claim that relief. But there is something called replacement business relief. So as long as they invest the proceeds within 3 years into another business relief qualifying asset, they get instant relief. So they don't even have to have a 2-year clock. Yeah. So as long as they held the original shares for 2 years, and then they reinvest within 3 years, they get instantaneous relief. So it's even quicker relief. And in fact, I'm working on cases at the moment with corporate clients that have just gone through that exact process, and they're looking to protect the value of effectively what they've worked for a considerable amount of time to build up. So those are the main groups, but there is one other group as well that's worth mentioning, and that is clients where a lasting power of attorney is in place. So generally speaking, once an LPA is in force, it's very difficult really to do estate planning without court of protection approval.
Yeah.
But it is possible to potentially do investments into a business relief solution where an LPA is in force. Again, I am repeating myself now, but this is absolutely an area where clients need advice, because whether this will work for them all depends on who are the attorneys, the beneficiaries of the estate, and so on, because there's been some recent updates from the Office of Public Guardian and the Court of Protection in relation to the kind of things they're happy with and not happy with. So it's imperative that people who are attorneys looking to do estate planning seek advice just to ensure they don't fall foul of their duties as attorneys.
Understood. As you say, that in some ways there's a simple concept at play here in terms of people with inheritance tax issues and possible liabilities, but the suitability or the appropriateness is going to be entirely dependent upon the individual scenario and the individual situation, which is, as you say, is where the financial advisor comes into play. That's been a really interesting and useful overview there, Anne. Thanks very much for your time this morning. Much appreciated.
Fabulous. Well, thanks for having me. It's been good fun.